Hello, 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 and welcome to Alexa's Room, where we are not law enforcement, we are not medical professionals, we are not lawyers, we are just people who have opinions about all things going on in the true crime community, including the Karen Reed trial. And it turns out, y'all, my earlier prediction, my earlier feeling in my bones was correct. The judge has declared this as a mistrial. So, what the heck does that mean for Karen Reed? What does that mean for the O'Keefe family? What does that mean for the Commonwealth? We're going to get all into all of that in today's video. First, by watching the clip. So, a couple of things happened today. I actually posted on my community tab if you didn't check it out. Earlier, the day kicked off with the jury essentially right off the gate saying, Judge, we still can't come up with a unanimous verdict. Really eloquently put by one of the jurors. A lot of people were speculating that one of these jurors was potentially a lawyer or somebody who maybe just understood the verbiage of how to use certain phraseology to make it seem like we're not singling anybody out essentially, but the way that the second note that was written to the judge that, hey, we're still hung, we can't do this, after being read the Tui Rodriguez instruction by the judge, it seemed like it could have been multiple people. And I again, my speculation, my theory is multiple people meaning multiple charges. That they were arguing about. Whether or not it was for the secondary murder charge, I don't really believe that. I just don't see there being enough evidence to prove she intentionally backed up into John O'Keefe and struck him with her vehicle, let alone struck him. He was struck with any vehicle. That's the camp I sit in. Is I just don't see by physics standpoint that's there was any evidence to prove that he was in fact struck by a vehicle. Other people argue it differently. Other people see the pieces of taillight being embedded into his clothing being enough evidence, and maybe that's the same thing, the same mindset the jury was in. So we're going to get into all of this, but first I wanted to go over the Tui Rodriguez stuff and what that means. So I actually pulled this from the Massachusetts government website. I shared it on my Twitter because, yeah, guys, I'm on Twitter now too. Sorry, I keep scratching my nose. It's just a little dry in here. So, yeah, we'll read this. Our Constitution law provides that in a criminal case, the principal way for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be attained or expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusion of other jurors. So meaning that they need to ultimately come up with a decision themselves and not just go along with the rest of the crowd. Um, and this is kind of essentially, and this was really well put by Mark Betterow and Melanie Little. This is kind of like a one last final pep talk that the judge can give to encourage the jury to come up with a verdict, a unanimous verdict. So we'll continue reading. Still, in order to bring six minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that the case be decided. You should consider, that you have been selected in the same manner and from the same source as any future jury would be. There is no reason to suppose that the case will ever be submitted to six persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced on one side or the other. With all this in mind, it is your duty to decide this case if you can do so conscientiously. So this is exactly what the judge read out earlier. We're not going to play that video. There's plenty of videos of her reading it out if you want to check it out. But we'll get to the verdict, which obviously, spoiler alert, it's a mistrial. get some of the reactions along with the defense comments after they exited court today. And if there's anything we can find in terms of the Commonwealth, I don't think they made a statement, but I could be wrong. I could have missed it. So we'll see if we find anything on that front. I'm still actively checking Twitter as I'm making this video. So bear with me. And we also have some other stuff too I wanted to dig in regards to this case that I thought was pretty interesting. Some stuff came out over the weekend regarding Paul O'Keefe. So, bringing some stuff to light that might, not that it's evidence related to this case specifically, but in terms of just um, mindset, feelings, thoughts. I thought it was interesting and relevant to bring up in this video. So let's keep going. In order to make a decision more attainable, the law always imposes a burden of proof on one side or the other, because remember, they have to prove it beyond a reasonable doubt to a moral certainty, and to a moral certainty in Massachusetts. Um, which is why she explained earlier in this clause, or in the Tui Rodriguez, they bring up that it has to be of his or her own opinion. In this criminal case, the burden of proof is on the Commonwealth. So it's not on the defense. They didn't need to prove a cover up, which some people might think was a mistake. Did they lean too hard on the cover up? I mean, if you believe it's a cover up, I personally do. There's too many coincidences that add up that make it feel, and too many loose acquaintances and connections that make it feel like this was done intentionally. Um, but to also admit that, we're admitting that these people are capable and smart humans, and part of me is like, "Are they that smart?" I just don't know, but, that's my thoughts, those are my opinions. But again, the defense doesn't have to prove whether or not it was a cover-up. They just need to prove there's reasonable doubt, and for me, it feels like the evidence or lack thereof shows there's so much room for reasonable doubt, so many questions, and with the federal investigation going on right now, it feels wrong for this trial to continue. So, continuing on, every part of it, every essential element beyond a reasonable doubt. If you are left in doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. If the glove does not fit, you must acquit. Or as Alan Jackson says, "We ain't got no quit." And there was a very cute moment with Kennedy saying the same thing too. So we're gonna get into their post-trial statements in just a bit. But in conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Whether there's a disagreement, those jurors who are for acquittal should consider whether a doubt in their own minds is a reasonable one. If it makes no impression on the minds of other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention, with an equal desire to arrive at the truth, and who have taken the same oath as jurors. On the other hand, those jurors who are for a conviction ought seriously to ask themselves whether or not they may reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. So, meaning, again, if you are like deadlocked on, "I believe she's guilty 100%, you can't change my mind," we have to dig deeper. Like, is it because of your own confirmation biases, or are you reasonably looking at the evidence presented in front of you? And I think a lot of the issues in this case, just, or at least with jury deliberation, was the fact that they weren't able to conduct readbacks. They weren't able to refer back to witness testimony. And there were a lot of slips that Lally made in his closing arguments that it could or could not be, according to, obviously I'm not a lawyer, but according to what um, a couple of lawyers on a couple of different shows that I watch said could be an appellate issue because they don't match up with what he was saying in opening statements or what the evidence that was presented throughout the case. So again, little things like this and the closing arguments are the last things that they heard the lawyers say to them. And while I think there was an instruction that the judge um, mentioned where they couldn't, I'm going to do full face for a second, couldn't consider closing arguments as like evidence, it's still the last thing that they heard. And if you're hearing Lally say, I hit him 4 times versus 3 times, and now he has a timeline, he believes is concrete and solid, and he's showing it to the jury. I mean, I don't know. It could be enough. It could be enough for people to feel deadlocked. So continuing on with this, and conferring together. Yep. On the other hand, those jurors who are for, they should ask themselves whether they should distrust the weight or adequacy of the evidence if it has failed to. I think I got this cut off. Oh, the verdict. Excuse me. The verdict. So this is thoughts in mind. So that's one part of the instruction. This is like an alternate version, which essentially says the same thing. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agreed to that verdict. Your verdict must therefore be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violating your individual judgment and conscience. Each of you must decide the case for yourself, but you should do so only after considering the evidence impartially with your fellow jurors. In the course of your deliberations, do not hesitate to re examine your own views and change your opinion if you become convinced that it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of, again, of the influence of the crowd. Are you going with the crowd, or are you making up your own mind based on the observations, just digging into the evidence that's laid out before you? Or for the mere purpose of returning a verdict, right? You're too tired and you're like, I'm over this. Fine, she's guilty, she's not guilty. So that is to protect both parties. You are not partisans for one side or the other. You are the judges of the facts. That's right. Not Bev, not the lawyers, the jurors. Your sole interest is to ascertain the truth from the evidence in the case. I would ask you now to return to your deliberations with these thoughts in mind. I feel like Bev did like kind of a hybrid of both, but again, I'm not going to go over that. But that's what the Tui Rodriguez is. It's just a simple jury instruction to kind of like kick them in the butt and be like, "Yo, guys, we're in overtime now. Like, come on, we can do this." And ultimately, they were still deadlocked. So now we are going to get into the actual verdict. I want to see if I can pull up an earlier clip. That's a whole lot of fan, man. Gonna miss that fan. I guess not. Okay. Here we go. And we're good. I guess I didn't skip too far back.
Thank you. Be seated. Closing session. 22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
I mean, I think we all knew that with the first note.
You guys for the jury.
Karen smiling at her family. That's Paul O'Keefe, John O'Keefe's brother, which we're going to talk about in 1 second.
Closing session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannone, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise to the court, please.
Do you guys think any jurors are going to interview with the press? I'd be curious. I think some of at least one or two might. Because they can do that though. And I'm sure they're going to go and Google and YouTube like crazy. And then some people are going to probably feel like, damn, like I'm going to kick myself in the butt right now. But
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July.
so this is the judge seeing if they're going to retry this case or not. Is the Commonwealth going to move forward? Is Michael Morrissey going to move forward? And we have a clip from him too, guys, that we're going to show in a little bit, because I know some people have only recently started getting into this case, and there's so much stuff and just prior pretrial hearings, just again, because this happened in 2022, remember, and it's 2024 now. So a lot has come out. A lot of stuff has happened. We're going to get into all of that. We're going to go over the pretrial stuff, etc. But first, what I wanted to dig into is, again, the judge is trying to see what's the status update. Are we going to do this again? Because she's likely going to be the judge. She knows the case. Typically, from what I've heard from the lawyers on different channels and panels I've listened to, I've watched on both sides, that seems to be what they think too. Is usually it's the same judge who will continue the case. Whether or not Karen Reed's team is going to stay 100% intact. Is Alan Jackson going to stay on her team, or is it going to be Yannetti flying solo? Is she even going to need Alan Jackson if the charges get dropped? I mean, we just don't know. But right now they're just figuring out dates of when they want to get a status update. So, and you hear the defeatness in Lally's voice. Like, he's like, oh, I have to do this again. Because more than likely he is going to be the one. Again, he knows the case. He is likely going to have to be the one if he gets enough pressure from the DA's office to move forward with another trial. I mean, I don't know what new evidence they would have access to perfect their case. I mean, I thought he did a pretty lousy job, and I think a lot of people feel that way on both sides of the fence, whether you believe Karen Reed is guilty or not, that Lally did a poor attempt at presenting even an accurate timeline of events. Like, we still don't know to this date when John O'Keefe was struck with a vehicle, let alone Karen Reed's vehicle. And that for me is huge. If we don't even know when, then how can you tell me the who? How can you tell me the where? How can you tell me the how if we don't even know when this allegedly happened? And there's no evidence to support your timeline. And you kept changing your timeline. I did hear from a couple of lawyers too that it could potentially, his closing argument compared to his opening argument could be an appellate issue. So again, we don't, because there were inconsistencies, whether they were done intentionally or not. Could that have also been a reason some jurors were feeling conflicted? Because again, the last thing that they heard were closing arguments from both the defense and the Commonwealth. And even though they're not supposed to consider that as evidence during their deliberation, it's still words that are ringing in their head. And if they're hearing Lally say, I hit him, I hit him, I hit him, I hit him, versus what he said in opening. I hit him, I hit him, I hit him. Is it a big deal? I don't know. It's hard to know because none of us are in the room, so we can only speculate. But right now they're trying to lock down dates on when and if there's going to be another trial. And Lally, I mean, what they ultimately decide on is a few weeks from now, before the end of July. So that's pretty quick.
I understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
It's Peggy O'Keefe. I don't see John's father here. I didn't even catch that the first time. I don't know who this guy is. I'm assuming it's a brother or an uncle. Anybody know who this gentleman is?
I would appear from my client.
Right, is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to be for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates. So
What about the 19th and 9th? Is that whole week?
no, that week's not good. The teaching that I cannot get out of.
She has a teaching engagement.
Do,
What are you teaching, Bev?
August 7th, 8th, 9th, any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't.
So it's interesting because she's about to say too, and I just cut her off, but Yannetti just suggested August, I think 8th or 9th, when I guess he gets back from vacation, and the judge is like, no, I can't wait that long. So she wants to know, what are we doing, and when, if this thing goes back to trial, when are we doing it? Because I want to get this over and done with. That's where she's at. She is so over this case. She's over this trial. She's over all the shenanigans, Lally shenanigans. She's over it. I don't think she wants to do another trial of this, but I don't see another judge. I just don't see that happening. So I don't know. I don't know. Is this gonna? I don't know. I'm so curious to see what that July 22nd hearing is going to look like.
Can't let it go that long.
Your Honor, so for those, Ms. Little and I are not available on the 22nd. We have a hearing in Los Angeles on the 22nd.
Okay.
We're proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Little and I probably will not.
Okay.
So this is interesting because I know a lot of people didn't catch the pretrial hearing stuff, but during the early pretrial hearings for this case, Karen was actually represented by Yannetti and his sister, which I didn't know. Very cute, like sibling duo, and they had brought on Alan Jackson, I think, a little bit later. And the judge and Bev was not having it. She did not like that Mr. Jackson wasn't able to fly all the way in for a hearing. I think it was like one of the shorter days or something. And she thought it was disrespectful and rude. So I find it interesting that Jackson now is like, well, I'm here, I don't want the court to think that, we're not invested in this, that we're trying to be disrespectful, but we have other commitments, because nobody thought this would go through July. I mean, here we are, July 1, 3 days before the 4th of July. And now we just get confirmation of what we thought all along, that yes, this was going to be a mistrial. So
you and your client will be here in person, Ms. Giannetti.
yeah. So Karen and Yannetti will be here. I wonder if his sister will be present too again.
All right. Thank you. We'll see you then.
So then there's going to be a quick, I don't know if it's in this clip or not.
Do you think the state?
Yeah.
And everybody was voting for it. What exactly?
They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit.
Alan, you're going to stay on? Working with Karen?
I just have two things to say, folks.
Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched and we ask for your continued support. I'm not from Texas like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is we ain't got no quit. Thank you guys.
No, Karen doesn't make a statement. I don't think she needed to. Obviously, everybody wants to hear from her, but I don't think she's going to say anything until that July 22nd hearing. It looks like it's raining in Boston, or in Dedham. Excuse me. So, I mean, this is interesting because if it does go to trial again, guys, I'm definitely planning on making a trip out there just because I mean, just the amount of support for Karen Reed and just seeing over the last couple of days, like a couple of protesters coming out, I think it'd just be an interesting take to see um, from a content standpoint, of course, but like also too from like I'm not a journalist, nor do I claim to be, but as somebody who's deeply fascinated in that and getting into reporting, I think it'd be important to be there. So if there is another trial, I'll see what I can coordinate. I grew up in New York, so Massachusetts isn't necessarily stone's throw away, but it's not too far. So I think it is possible to make a trip like that happen. So if you guys are interested, if that is what ends up happening, I mean, again, even with the Koberger trial, I heard that they're set to go to trial in 2025. I mean, think about all the craziness behind that. I haven't been following that the Idaho 4, I believe it is, or Idaho 5 case too closely, but as that trial approaches next year, I'll be covering that as well too. But there I mean, that happened last year, and there's been just so much delays and back and forth and pushing things back. So I mean, if Karen Reed does get retried, when will it be? Will it be a year from now? Will it be 6 months from now? Will it be 3 months? I mean, we just don't know. I don't see what other evidence could help the Commonwealth. There's a federal investigation going on. And I don't know if the feds are going to step in. I don't know if there was some kind of conversations going on behind the scenes where the defense kind of expected a hung jury. I don't think they did. I think everybody was a little surprised, and over the last few days, I think that became the imminent reality that, yeah, okay, it's definitely not gonna be guilty, but is it gonna be not guilty? Or is it gonna be guilty of a few I just don't know, and I'm so curious to see what everybody's going to be thinking over the next few days as just more stuff continues to unfold, but there's other stuff I wanna go through, in this video before we call it. Um, like I said, there's a police report. It was confirmed that this is real. This is a real report of Paul O'Keefe getting charged with an OUI. I think it's called an OUI in Massachusetts for drinking and driving and getting into a motor vehicle accident. And it looks like it was in 2020. So I think some people said it was a few months before John O'Keefe passed away. If it's 2020, John O'Keefe was murdered in 2022. So this was quite a bit before, but still a little bit ironic. There was also a cleaned version of the Jen McCabe call, 911 call that was released. I am going to try and find that so we can listen. And then there was another incident that happened involving another police officer, the police chief actually, of Canton, who struck a pedestrian with her vehicle. Again, a lot of coincidences, not necessarily particularly directly related to this case, but when you see all of these different things going on around and you get like kind of you zoom out of the Karen Reed case and you just look at, okay, what is going on in this town? Who are the people who are running this town? Who are the people who are in charge and supposed to keep their people safe? What are they doing? How are they using and taking advantage of their badge? That's when I land in the camp of, is this a cover up? Are these people capable of doing these things? I think it's possible. I think anything's possible. I never thought I would be able to grow my own business to 100K having no college degree and being a dancer for 6 years, but I did it. So I believe anything's possible. I don't think anything's out of the realm of possibility. In the same breath, if Karen Reed really did this and there's evidence to support this, show it to me. I wanna see. I wanna see. I want justice for John O'Keefe. But right now, it just looks to me like there's a woman who's been wrongfully accused of doing something she just physically could not have done. That was proven by experts who were hired by the feds, the federal government. You don't get more legit than that. So, yeah, I'm gonna trust their word a little bit more. Are they part I know some people, some other content creators have thrown around the allegation that, oh, they're trying to please their bosses by just making this information up. And I just, again, what do these people have to gain? And it's not like they just got hired by the feds for this one particular case. Like they work with the federal agencies regularly. That's what they testified to it. We can go back, we can play the clip. Like this isn't their first time around working with the feds. Just for this one case, why would they care? They don't know Karen Reed from a hole in the wall. Why would they conspire with her together? It makes no sense to me. And if you're gonna believe in that conspiracy, then on the other hand, again, how can you see that a cover up is impossible? So I'll leave that with that. Let me know what you guys think in the comment section below. Always open to having respectful conversations. And I know some people believe, there were a couple people who commented over the weekend, Karen Reed's guilty. But Lally presented a terrible case. And yes, I agree. Lally presented a horrible case. He did not do the Commonwealth any help. Any help. And whether or not he was just phoning it in because he's just a paycheck collector, or he did his best and he's just not as skilled as Jackson and Yannetti. And I don't think anybody can disagree with that. No matter what you think about them as people. We're not there to judge their character. We're there to judge whether or not they were able to prove their case for their client. Prove that there is reasonable doubt. That's their only job. They don't have the burden of proof to say, did she do it? Beyond a reasonable doubt, that's the burden of the Commonwealth. So, I'm going to get into this Paul O'Keefe stuff first. I know Turtle Boy, he did a 911 breakdown of it. And I might just link to that in the description. But I heard that there is a cleaned up call. Cleaned up call. Enhanced audio. Oh, yep. Well, this is from LTL Media. So we'll get into that one first. Then we'll get into the Paul O'Keefe stuff and the stuff with the police chief of Canton, who I believe was reelected, by the way, which is concerning if you're striking a pedestrian who is literally suing you for doing that and you get reelected, or not reelected, but you get, reelected. So This is the one from LTL Media. Go give it a follow. I haven't heard
True
this.
Crime Podcast, and
I haven't heard this one. He has a really interesting channel. I believe his story is one of his friends was murdered and they weren't able to essentially prove who did it, what happened, and now he's dedicating his career towards digging into cases like this, cases where he feels there is an injustice being done. So really cool stuff. There's a couple of people with channels like that on YouTube in the YouTube community. So I can't even imagine what that's like. But we're gonna get into this and we'll listen in.
just wanted to chime in a little bit and talk about the Jennifer McCabe recorded 911 call via a voicemail that Turtle Boy released on his channel the other day. And I went and actually listened to it. It's about a 4-minute and 6-second video. And to be honest with you, it was very difficult and hard to hear what was going on in that call. So what I decided to do was actually sat for a couple hours today, put it into a editing program and tried to filter out some of the noise. At the first listening to it, it's very distracting. There's hiss, there is windshield wipers that are going on. The voices just seem
Screaming.
really muted. So what I did was threw filters on it and EQ. I sat with it probably about 6 hours today, and I came up with a couple of versions of it. And the one that I've come up with now has kind of enhanced and cleaned up the audio. So I hope this gives some more clarity as to what's being said and what's going on. I also want to go on record and say I hope Turtle Boy doesn't mind that I did this. I don't think that he would. And I totally want to give him 1,000% credit for actually putting this out here. I'm just trying to give a helping hand and enhance the video here for people.
And again, I want to make that clear too, guys. When I'm sharing content like this from other creators, like this, again, I'm not an expert. I'm not there. He's actually boots on the ground, LTL Media. He's been filming or reporting alongside the Karen Reed camp. He's gotten permission, direct permission from her team, her family to do so. So I want to give him a shout out. Please give him a follow. He's doing great coverage of this case. He brings on a ton of great experts that, again, if you're in the camp of Karen Reed's not guilty, you'll definitely enjoy their content. So definitely shout out to LTL Media. Go give them a follow. Again, I'm just trying to do my part and share this content, share the work of other creators, and give my own personal commentary on my thoughts, feedback, and opinions on what I'm hearing as well too. So that being said, let's dive in.
To listen and get a more clear
And I hope he
perspective of
doesn't
what's going on.
mind
So
that I'm
I'm
doing
going to
this.
play that here. I hope you all enjoy it, and I hope that this helps. I'll talk to you all soon. Thanks for sharing, and subscribing. Comment down below. I'd love to hear what you think. All right, here we go.
Yes, I need someone to see
34.
Okay.
So that's Jen McCabe, who you heard before. I believe she's screaming Kerry, Kerry. That's what I could make out. That was Karen Reed screaming. So she was calling John O'Keefe while they were pulling up. She notices he's laying on the ground, drops her phone. It leaves a voicemail. This is the voicemail to the 911 call. So that's why you're hearing all that crazy background noise. This isn't the actual 911 operator call. I don't know if that's going to be released. I don't know if it has been released. This is the only call that we've heard, and I believe this is the call that was played for jurors as a recording of the recorded 911 call. So that's why it's a little bit harder to hear and make out. But this is Jen McCabe now speaking.
Well, get now. There's a man passed out in the snow. Yes, I need someone to see 34th year road. Get now. There's a man passed out in the snow.
There's a man It almost seems like she said plop down. So I'm gonna go back and play that one more time.
Yes, I need someone to see 34th Yearby Road, Vietnam. There's a man passed out in the snow.
Yeah, I can't make out if she's saying plop down or face down.
I can put that. Okay. I know. Where's the blanket? I don't see blanket, Terry. Yes, I need
So the person screaming in the background is Karen. She keeps screaming for blankets.
I know, I'm on the phone with Andrew. I know, honey, I know.
She's saying that you're not helping yourself? I wonder. It is so hard to hear. So that's the enhanced audio. Like I said, give LTL Media a like, subscribe, and follow. I mean, even with the enhanced version, I just don't know how much clearer you could really hear anything, in my opinion. I mean, it's a lot of hysterical screaming on Karen Reed's part, like we heard played in court. I mean, you don't really hear anybody else freaking out. The argument you can make too is like if somebody's on the phone calling the 911 operator, and I could see people arguing this, but that's why Jem McCabe might seem so calm, cool, and collected. But again, if John's your good friend, wouldn't you be, I guess, the one freaking out a little bit more? And also too, the house that you're at, I mean, these are people who are in the police department. Brian Albert is a police officer. Like, he's a detective. He's a first responder. They are 911. Why wouldn't you call them? Like, why wouldn't you go in the house first? I just that that's the part of me that doesn't make sense. It's not like these are just random folks, right? Who don't have any tie to the police department at all. These are police officers or people who are friends, family of police officers. They are 911. You can't get more 911 than having your friend who is likely deceased at this point on your front lawn. I just don't understand why that wasn't the first instinct, but I'm not going to pretend I know what it feels like to be in a situation like that. I can't judge. But for me, it feels weird. That would be the first thing I would do. Screw 911. They already got 911. Somebody else can call 911. Somebody wake up Brian Albert. Get the Albert. Get him up. Get some blankets. While you're doing that, cool. We're going to call. While the first responder is working on him trying to get him back to life. I mean, he's more trained than Karen Reed is to give CPR unless she's taken CPR classes. Certainly he would know. He'd be the best guess. He'd probably be the best one to make the 911 call. Because he knows how to communicate in stressful situations. Why is Jim McCabe making the 911 call? I get it because you're first approaching up to the scene, but I just feel like instinctually that would be my instinct, but that's my opinion. That's why we have these discussions. That's what I would do or what I think I would do. But really, again, do I even know? No, I don't. I don't know what I would do. All I know is that I hear a hysterical woman on that 911 recording. And it's not Jen McCabe, it's not Carrie Roberts, it's Karen Reed, who's hysterical. And that for me is the most damning evidence to prove that she did not intentionally hit him with her vehicle. That for me proves that. Like she did not know. If she really did it, which again, I don't believe she did. I don't think physically it was possible for John O'Keefe to have sustained the injuries that he did based on the evidence that was presented during this trial by being struck by a vehicle. That's my opinion. So that's the 911 call with the cleaned up audio. Again, sorry, I keep itching my nose. It's like very dry in here. Just make sure I'm not missing anything on Twitter first. Oh, all right. So, okay. Well, Ted Daniel, who has been on the scene of the case or on the scene of the court, Commonwealth has announced they plan to retry the Karen Reed case after a hung jury today. There will be another trial, according to DA's spokesman. Okay, if that's true, that's crazy. That is wild. We already heard this clip from Jackson. I don't know if it starts earlier.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges,
That's the whole
based on
clip.
compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and
We
they'll
saw this
continue
part.
to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit.
Hey, he didn't answer that question, so I don't know if that's just him trying to keep people pumped or if he's gonna work maybe remotely as a consultant, maybe recommend somebody else. I don't know. I don't know what that is. Lally couldn't make it. Yeah. So, I mean, according to NBC 10, breaking news. Norfolk District Attorney's Office announced that they will retry the Karen Reed case after a mistrial. Of course, I mean, like I said, guys, I think I think Morrissey is so unaware and just so narcissistic that he feels like he needs to see this through. And when the best thing would be is just let the feds do their conduct their investigation, and then after all is said and done, if you feel like you have sufficient evidence to move forward, because I don't see what else could potentially come into light. What other experts are you going to bring in? Are you gonna have Trooper Paul testify again? That was a circus show. That was a complete circus show. So, all right, NBC 10. Is there anything more on that? Or is it just the headline? Full video. I mean, I think that's all they have right now. Is this a clip? Oh God, is this more? Oh my God. Wait, hold on. And I want to play that clip from Morrissey as well too. So this is from NBC 10. This was posted 38 minutes ago.
Expert on the phone, Michael. Judge Cannone did say that they would reconvene July 22nd at 2 p.m. to figure out what comes next. So you tell us what comes next in something like this.
Well, the prosecution will have to decide whether they want to retry her or not, and I expect that they will decide to retry her. It's the death of a police officer, and the prosecution feels strongly that their case is correct, that they've got the right defendant. And so then the question becomes, will the defense attorneys be able to come back? Can they fit it into their schedule? The financial issue becomes a question as well.
Yep.
And then ultimately, how do their schedules all work as to when this might be retried? There's always the possibility that the government might decide not to pursue a second trial. I don't think that's likely. There's also an unlikely possibility that they could strike a deal.
I mean, again,
as well. Again, I think that's an unlikely possibility here, JC.
Let me just ask you, how much say does the O'Keefe family have when it comes to the prosecution's decision whether or not to retry?
Not a lot. I think obviously the district attorney would take into account their feelings, but either whether they were strongly one way or the other wouldn't necessarily be dispositive. As the chief law enforcement officer for Norfolk County, he has a responsibility to everyone involved to really take a hard look at the case and see whether it makes sense to go forward again.
All right, Michael, joining me now on the set is Glenn Jones. Glenn, as you heard, that has been declared officially a mistrial, which is where we were leading based on the jury's note to Judge Cannone.
okay. So, I mean, that was actually an interesting question too. If the family has any weight, obviously they're going to want to consider. They want to consider all factors, but I think more the biggest thing on their brain is not so much doing it for the right reasons for the family, but more so for themselves and politically as well. Are they politically motivated? This is the this is the statement. Michael Morrissey, he's a DA. I think he's been sitting as the DA for the last 25 years. I know I made a video going over his background as well. He also was in the Senate as well too, the House of Representatives as well. So he had deep political ties. So make no mistake, these things are possible. These things are possible. So we're gonna go over this video. This is where he's talking about the harassment of witnesses in the Karen Reed murder case.
This will be the first statement of its kind.
So he's specifically referring to harassment, meaning not by Karen Reed or her team, but by people, journalists like Turtle Boy, asking questions to people like the Albert family, Chris Albert, Brian Albert, and the Matt McCabe. So this is him addressing this.
In my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died.
That's not true because the Apple Health data, if you want to look at the Apple Health data, it shows him descending 3 flights of stairs. So how is that being done? That's the closest thing we have to proving he was. You don't have enough evidence to prove he was not in 34 Fairview. You don't. So you can't say that, Michael Morrissey. You can't.
Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home.
How?
11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found...
That's not true. That's not true. Then we can go back to the medical examiner's testimony to prove that. And we will. And we will on our next video. 100%. Yeah. I want to do a deep dive comparing this to what the medical examiner's testimony. What she said was, it could be consistent by this. It could be consistent with this. What she didn't do is say it was consistent with a motor vehicle accident, like Proctor and Chico put together on like a silver platter, Buchanan put together for her right there on a silver platter. She did not say that, Michael Morrissey, and we have the receipts to back that up. But continue.
That the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness.
I mean, do you think like if the tables were turned, they'd be defending Karen Reed like this? No. So why is the DA going out on a limb making a statement like this? Aren't you I mean, I get it, you're trying the case, but why make a statement like this at all? When you know there's a federal investigation going on. Why would you even push this thing to trial, bro? Like I just don't understand. Help me understand, because this makes you look really, really biased. Like, these are your buddies and you're trying to look out for them. He has deep political ties. You don't sit on the Senate, I think, for 25 years or like 20 years for the Senate, for the House of Representatives. Then he's the DA for 25 years. Meet a lot of people, you shake a lot of hands. You can't tell me that that is impossible. You can't tell me that this isn't political. Because it is.
We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the
I mean, we have the receipts to back it up, and we can, I mean, like, again, people can, yeah, it's the court of public opinion. That's why I call this channel the court of public opinion, because it's my opinion. But we can go back. We can do our homework. And the jury, unfortunately, can't. Unfortunately, the jury can't research and see that, yeah, Colin Albert did perjure himself on the stand by claiming that he only fights with his brothers occasionally. He doesn't get into fights. He never got into a fight like that, but there's video evidence of him getting into fights. So, that's a lie. Katie McLaughlin also lied about her relationship with Caitlin Albert. Might not think it's a big deal, but it's a big deal. It's perjury. It's not truthful. So yeah, the internet, people like me can go back, watch testimony. We can go on Facebook. We can do our due diligence. And whatever the defense can prepare on their end and bring into discovery and what's allowed and what isn't allowed, some things aren't allowed. Some things the judge can decide if she's going to allow into evidence or not. So they're not going to get the whole picture. They're never going to get the whole picture.
facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police...
Which is also, like, absolutely crazy to me. The lead investigator, and did he call him the lead investigator?
This is taken in by vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence.
The state police trooper. So he's not going to say lead investigator, because I think he called himself, I think he called himself, what's it called? Like a case investigator or some like made up like role in his department when he's been referred to as the lead investigator. So, as the lead investigator, why weren't you on the scene until days later when all this evidence started to reveal itself? That, I mean, it's like, yeah, is it my brain being like I watched too many true crime shows? Probably. But I would think common sense would tell me if you're the lead investigator, you would want to first go to the scene of the crime. before you start piecemealing all of the information together. You want to get statements from people yourself. Everybody, you want to go in the house. You want to make sure. Again, and I think Melanie Little brought this up too in one of her streams. It was a really good point of with the cocktail glass. Like, you see pieces of glass, why wouldn't you go in the house and be like, "Hey, like, can we just, like, take a look?" Even if you're just coming at it from a friendly perspective of, "Okay, like, we don't think you guys are suspicious, but we just want to see, do you have glasses like this?" Like, we're not saying that you did it, but, like, did he drink any of your glasses? Or, like, did anybody, I don't know. Like, how did that broken glass end up there? But the investigation started and stopped with Karen Reed pulling up and allegedly saying, "I hit him, I hit him, I hit him." Or if you're Lally, "I hit him, I hit him, I hit him, I hit him."
Outside 34 Fairview Road was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing the 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having
Not
no
at
opportunity
34
to plant the
Fairview
evidence, as has
Road,
been suggested,
but somebody
Proctor
else
would
could have.
have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and
That's a
had no
lie.
conflict. And he had no reason to step out of this investigation.
Morrissey, that is a lie, and you know it. He had a loose connection to the Albert family. He worked on cold cases with Kevin Albert, Brian Albert's brother. You can't, they're drinking buddies. You can't tell me. Stop.
Investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
It is the stop. I'm sorry. Like, I just can't with the stuffy nose tone. It needs to stop. Yeah, what do you think about that? That's the DA. He's the guy who's calling all the shots here. So there's that. I want to do a side by side though, especially when he was talking about the medical examiner and what she determined or didn't determine, because again, when she testified, that I did a whole video on this. All she kept saying, from what I recall, is it could be, it could be, it could be, it could be. So did she change her original analysis before she took the stand? I don't, because otherwise that's a lie. That's a lie, Morrissey. So now I want to get into this report. Again, I'm not here to drag the O'Keefe family, but I do believe that two things can be true. Meaning that I think you can be a flawed human being, but also be the victim of crime or have a loved one who is a victim of crime. And I think those are two separate entities. However, I find it very surprising that he isn't a little bit more understanding or sympathetic towards Karen Reed, considering Paul O'Keefe went through a very similar situation where Karen Reed allegedly bailed him out of jail for an OUI. I can't confirm if that part is true, but I can confirm that this report is legitimate. So we're going to pull it up. This is the police report for Paul O'Keefe, who was involved in a motor vehicle accident while driving under the influence in, it looks like, 2020. So, date and time 10/11, October. Woo. October 11th, 2020. So this was, I know some people have said like, oh, this was only X amount of months before his brother passed. And I mean, that's almost like 2 full years. So that's quite a significant amount of time before then. And I believe at this point, and feel free to correct me, y'all, if I'm wrong, but I believe at this point, Karen Reed and John O'Keefe were back together for at least like a year or 2 prior to this incident happening. I believe, please don't quote me if I'm wrong. They were together about like 4 years because they had dated prior and then they like broke up and then they got back together, and that's how they rekindled their relationship. So in terms of timeline, if they were together, it could make sense that she would bail him out. I mean, she has the financial means, or had the financial means. Now after this trial, I mean, she definitely is probably not as financially well off as she was. But yeah, let's get into it. So I have it. Let me stop sharing on the screen. Let me see if I can pull it up. I can't do that. So I want to zoom in. It's a little hard to read, but I'll read it out to you, and I'll include it in the video description. So this was first from a Reddit thread, and again, I don't look to Reddit as like a legit resource for news, but this was confirmed by multiple sources that this is a real report. So whether or not Karen Reed bailed him out, I don't know. I think it's just ironic. So Vehicle 1 was traveling south on Bedford Street. Vehicle 2 was in the northbound lane during turning left into Joe's Gas. 33 Bedford Street. Vehicle 2 left in front of Vehicle 1, failing to yield right away. This caused Vehicle 1 to strike Vehicle 2 and caused Vehicle 1 to veer off the roadway, crashing through the large electronical Joe's Gas business sign. Operator of Vehicle 1 sustained serious injuries, was transported to, guess where, guys? Good Samaritan. Same hospital John O'Keefe was transported to. Operator of Vehicle 2 sustained no injuries and was placed under arrest. So Vehicle 2 was operated by Paul O'Keefe. So again, just to reread, Vehicle 1 was traveling south on Bedford Street. Vehicle 2, Paul O'Keefe, was in the northbound lane turning left. Vehicle 2 turned left in front of Vehicle 1, failing to yield right of way. So he was supposed to go, he wasn't supposed to go when he went. Then he was transported, the operator of Vehicle 1 was transported to Good Samaritan for serious injuries. And he was placed under arrest. Paul O'Keefe, operator of Vehicle 2, received Massachusetts uniform citation. Vehicle 1 sustained heavy front end damage. Vehicle 2 sustained heavy damage to the front passenger side. Very interesting. Both vehicles were towed from the scene of Midtown towing. So I think there is somebody included. I don't know if it was this one. There is a picture of it. I'll see if I can pull that up as well too, but I want to get through the rest of this incident report rather. So on 10/11/2020, Officer Andrew Cedarquist was assigned to uniform patrol in fully marked Lakeville Unit 164 at approximately 16:36 hours. Dispatch advised a 911 call was received reporting a 2-car motor vehicle accident on Bedford Street by Joe's Gas. Officer Nora Cross and I responded to the scene. Sergeant Pacheco, Officer Tajay, and Captain Joyce were reported to also be responding, which I think is awesome. Awesome. I think that's interesting that there's so many people. Like the captain is is going on the scene. I don't know if that's standard protocol, but it seems a little strange that the captain would also be responding to something like that. I mean, Lakeville, maybe it's a small town. I imagine it is. So I don't know. Maybe things like this don't happen often, and that's why it was kind of an all hands on deck. But this already kind of gives me interesting vibes. While responding to the scene, Officer Norcross called over the radio that he would be performing a C-spine on one entrapped operator. So I imagine that is the one who, the injured party, the operator of Vehicle 1. It should be noted Bedford Street is a public way owned and maintained by the Commonwealth of Massachusetts. At this time of day, Bedford Street experienced heavy traffic flow. So it was a busy day, middle of the day, it seems like, or like early evening when this happens. On the scene, I checked on the injured operator, later identified as Carl Prather. So he was an older gentleman. He was born in 1947. He was operating Massachusetts registration. I guess that's the license plate. While Officer Norcross was administering care to Prather, he stated that Effer turned right in front of me. Prather appeared to be in excruciating pain and complained of neck pain and loss of feeling in his extremities. Yikes. Prather's vehicle had heavy front end damage and came to rest after striking the mobile gas sign. Again, the pictures that I've seen, if they are legit and they look legit, that's crazy. The officer Norcross administering care to Prather, I asked who was operating the second vehicle. A Paul O'Keefe, he was born in 79, raised his hand and stated in a slurred, confused manner, I was. O'Keefe was operating Massachusetts, registered in blah, 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 which was facing westbound on the southbound land of travel. His vehicle sustained heavy front passenger side damage, appearing to be totaled. I asked O'Keefe to detail what happened, to which he stated, I was driving this way, pointing northbound, and turned into here at the gas station. He just hit me. I asked O'Keefe if he was injured and needed medical attention. He stated, no, I'm fine. I didn't get hurt. With Sergeant Pacheco, Officer Tajay, and Captain Joyce now on the scene, I returned to my cruiser to report the vehicles to dispatch. At this time, Lakeville Fire had arrived on scene and provided high-level care to Prather. I returned to O'Keefe and asked him to detail the events. As O'Keefe was speaking, I detected a moderate odor of an alcoholic beverage coming from his person, so probably on his breath. I was unable to detect this at first due to my mask covering my mouth, because again, this is during COVID. So yeah, this is 2020, guys. This is like towards the tail, not the tail end, but I would say I remember traveling in September, I think it was of 2020, and I traveled to where I live now in Nashville, and no one was like wearing masks down here. It was very insane. But at this point, this is New England, so they're a little bit stricter with the COVID stuff. Exposing my nose while speaking with O'Keefe, I observed that he was wavering from side to side, appearing to have difficulty maintaining his balance. I also observed his eyes to be bloodshot and glassy. When O'Keefe would blink, he would open and close his eyes slowly and delayed. I asked O'Keefe where he was coming from, to which he stated in a slurred, thick-tongued manner. Look how detailed the language is in these reports, guys. Pretty refreshing, right? I came from LeBaron County Club after golfing. So he's a golfer. As O'Keefe spoke, I identified the odor of alcoholic beverage was coming from his mouth. The Labaron Hill Country Club is a gold club that has a bar and serves alcohol. I asked if he had any alcoholic beverages while he was golfing, to which he stared at me blankly for a few moments before stating, yes, I had 3, in a slurred manner. I asked him what kind of alcoholic beverage did he have, to which he stated in a slow, confused manner, beer. Due to the moderate odor of an alcoholic beverage, his slurred and confused speech, bloodshot and glassy eyes, and obvious lack of balance, I asked if he would perform a few roadside assessments to determine if he was okay to drive. O'Keefe stated, "Yeah, sure," in a slurred manner. And it's so interesting too, because, like, side note, before we get into the rest of this, I was actually pulled over once. This was when I was working at the club, and this was before we couldn't make like a left turn going out of my club because they were on the right side, and there was like this fork across the street. So usually what I would have done is I just drove across, got in the left turning lane, and banked to Huey because I lived west and I worked out east on Long Island. And I got off, early hours of the morning, 4:30 in the morning, hop in my car. I used to be able to drink on my job. I was able to at the club. Clients could buy me drinks if they wanted to. At the time, I had only had one shot of Jameson. Earlier, way earlier in the night, I think probably around 9 o'clock, 9 p.m. at night, drinking tons of water. So not intoxicated by any stretch of the imagination or legally. So totally coherent to drive. I was just exhausted and I wanted to get home, obviously, as quickly as possible because I was tired. And I banked my Yui like I usually did. There was no sign saying that I couldn't make a U-turn. I got pulled over by a very angry Suffolk County police officer. Don't know his name. Who just off the gate started accusing me of drinking and driving. He didn't have me do any of like a breathalyzer or anything like that because again, he was watching me. He was parked up across the street. He was watching me pull out of the club, and he assumed I was under the influence, and I wasn't. And I think he was upset about that. So he caught me doing this alleged illegal U-turn, which wasn't. Spoiler alert, I didn't get a ticket, but that's not why. So he pulls me over, very angry at me. I'm confused why I'm being pulled over. Nervous. I'm 19. I've never really been pulled over in my life, and yeah, he started like doing the like check to see my eyes are glazy. He was saying my eyes are glazy. I'm like, it's probably because I'm tired, and I have to drive 45 minutes to go home now. So didn't do a breathalyzer, none of that. He checked out my license. He asked where I was from, and he asked where my dad went to high school because I was from the same town where he grew up, and he let me off. And he was all calm, cool, and collected once he found out that my dad went to the same high school as him. So again, do these things happen? Yeah, they can happen. They can happen anywhere in the world. I mean, I didn't get arrested, thankfully, but I also didn't do anything wrong. But I could have been a victim of getting arrested. I could have gotten charged with a DUI, even though I didn't have any signs of being under the influence. And I think he was upset about that. So, again, all this to say that all of this stuff in this case is just, especially with drinking and driving, it's possible. It's 100% possible. Okay, so I requested O'Keefe to walk over to the side parking lot away from any debris. I had pointed to an area flat and clear of cracks and debris. O'Keefe appeared confused and did not move. I asked him again, to which he looked at me, confused with a blank stare. O'Keefe then appeared surprised without speaking and started to walk over to that area as imbalanced by widening his stance and taking smaller steps. As O'Keefe walked over, he would waver from side to side slightly, and would roll his feet to catch himself from tripping. As he got to the area, God, what a day that not have body cam, right? I asked if he had any injuries once more, or if he had any past injuries that would prevent him from conducting any balance testing. O'Keefe raised his shoulders and arms, stating, "No, I'm not hurt. I'm just fine." I asked again if he had any past surgeries or injuries, to which he stated, "Nope." I asked if he wore contacts or glasses, to which he stated, "Nope." Interesting use of language. I advised him that I would now begin instruction for the first assessment. I mean, I think it seems like this. I mean, we don't know. We haven't seen body cam footage if there is any, but from the report, it seems like this officer did his due diligence of being like, okay, well, like giving you the benefit of the doubt. Like, are you tripping because you have a leg injury? You've hurt yourself before. So I think that's good. And I like the amount of details because you can picture him going through this. I instructed O'Keefe to remain with his feet together and his hands down his side while I gave him the initial instructions for the horizontal gaze nystagmus test. Nystagmus test. Then gave him instructions to follow my finger with his eyes. So that, again, that's what I had to do with the cop, except he used a flashlight. Only keeping his head completely still. O'Keefe appeared confused and stated that he understood. I first checked for resting nystagmus, to which none was present. Through the first few passes, O'Keefe moved his head. I stopped the test once and reiterated that he was to keep his head still. So he couldn't move his eyes and follow his finger without moving his head. Stop the test. I checked for equal tracking, which yielded positive results. Once equal tracking was observed, I proceeded to observe his eyes' ability to smooth track my movements. O'Keefe was showing a lack of smooth pursuit through numerous passes. I then held my finger at maximum deviation, double checking both eyes, which yielded distinct and sustained nystagmus. O'Keefe's eyes then showed onset nystagmus prior to 45 degrees. Throughout the test, O'Keefe was swaying from side to side, slightly appearing to have difficulty remaining in a stationary position. For the next assignment, I began to give him instructions for one-leg stand. I began the demonstration at the starting position with both feet together and hands down his side. I then instructed him not to begin the test before I gave instruction to do so. I demonstrated by raising my left foot, stating that he could use whichever foot he felt more comfortable with. So he's like, yeah, if you're not a right, like, I'm not going to hold that against you. Which, again, it seems like this guy was just doing his job the right way. Approximately 6 inches from the ground with his toe facing down. Furthermore, I also demonstrated the straight-legged manner and held the stance. I then instructed that when I told him to begin, that he was to look at the elevated foot and count out loud 1, 1,000, 2, 1,000, 3, 1,000. In that fashion, reiterating that it was a 30-second test. I asked if, okay, wait, so he had to hold that? I don't even know if I could do that. I'm not gonna lie. I'm not a very coordinated person as is. I asked if O'Keefe understood the instruction, to which he appeared confused and did not answer. I asked if he wished for me to give the instruction once more, which he stated, no, I got it, in a slurred manner. When I gave the instruction to begin the test, O'Keefe raised his right foot approximately 2 feet from the ground. O'Keefe also raised his arms at a 45-degree angle past the allotted 6 inches and hopped slightly to maintain his balance. O'Keefe then bent legs at the knees. Lowering his stance, he counted to 2 before hopping and counted 3, 1,000 twice. O'Keefe then counted to 6, 1,000 before dropping his right foot to the ground and asked, am I done? I advised him that it was a 30-second test, which he looked at me confused while attempting the assessment. O'Keefe wavered from side to side, hopped twice, bent his knees, raised his arms above the allotted 6 inches, and was unable to hold his raised foot approximately 6 inches off the ground. I instructed him once more. It was a 30-second test, advising him to continue. O'Keefe paused for a moment, appearing confused before attempting the test once more. O'Keefe raised and lowered his foot between 1 to 2 feet, raised his arms approximately 45 degrees, shuffled his left foot to maintain his balance as he wavered from side to side and stopped, counting at 7, 1,000. I concluded the assessment. It should be noted O'Keefe had on flat-soled shoes that weren't in good condition. So again, it seems like he's just trying to give him the benefit of that. For the last assessment, I began to physically demonstrate the walk and turn while giving verbal instructions. I instructed O'Keefe to stand heel to toe while I demonstrated the test. So, when you've seen those videos, right? O'Keefe was unable to stand heel to toe with his feet planted at an angle and periodically raising his arms and legs and his knees in an attempt to remain in the position. I remained in the heel to toe fashion properly while I waited for O'Keefe to take the proper stance. O'Keefe remained with his feet offset and angled, appearing and to ignore my request and assume the starting stance. I then demonstrated 3-turn, making small, short, choppy steps. Took another 3 steps back. I reiterated that it was 9 steps forward, a series of small but short, choppy steps for the proper turn, and 9 steps back, counting out loud with his hands pressed against his sides. As I gave instructions to begin, O'Keefe took 12 steps. O'Keefe counted 12 steps with his arms raised over 12 inches. O'Keefe took the first 6 steps, heel to toe, with his feet angled. While taking the first 6 steps, O'Keefe raised his arms, bent his knees while wavering from side to side. O'Keefe then stepped offline, so off the chalked line, on 7, 8, 10, and 12. O'Keefe stopped the test after casually turning around. I advised that it was 9 steps back, to which he stepped back onto the yellow line and took a series of 10 steps. O'Keefe missed heel to toe, wavered from side to side, and stepped offline multiple times. I approached O'Keefe and advised him that he was under arrest. Okay, so after failing all 3 tests, he gave him 3 shots. He failed every single time. O'Keefe was secured into properly fit double-locked handcuffs that were for booking. Officer Norcross remained on scene to assist Midtown Towing with the vehicles. I wonder, Midtown Towing, is that the same company that towed Karen Reed's vehicle? I'm curious if anybody knows. Because I imagine this is from the Commonwealth of Massachusetts, right? Going back to earlier. Bedford Street is a public way owned and maintained by the Commonwealth of Massachusetts. So I'm curious if they use the same towing company. If you guys know, let me know. I secured O'Keefe into the rear of my cruiser, where he awaited transport to the station for booking. Officer Norcross remained on scene to assist Midtown Towing with the vehicles. Spoke to the clerk inside of Joe's Gas. I mean, I'm sure that was terrifying to see somebody driving into your sign during a shift in the middle of the day. She advised him that there is possibly surveillance footage that may have captured the incident. Ooh, that'd be interesting if that leaks. I will have the day shift follow up in the morning to attempt to retrieve the footage. Was it retrieved? I'd be curious. I cleared the scene and transported O'Keefe to the station for booking. Once at the station, I opened the rear cruiser door to escort O'Keefe into the station. With the rear door open, I detected a strong odor and alcoholic beverage through his face mask, which was coming from the prisoner's compartment. I escorted O'Keefe into the booking room, where he was processed in accordance to the Lakeville Policeville Department policy and procedure. Sergeant Pacheco, 33A, and request to submit a chemical test pursuant to general laws, CH 90, section 24, after being chapter 90, section 24. After being advised of the penalties for such refusal consequences, O'Keefe elected to refuse the breathalyzer, so he refused it. It was processed as such. Sergeant Pacheco processed O'Keefe as a refusal in the Dragger Alco test 9510 with Officer Tajay as a witness. I afforded. Okay, so see like too how they're documenting every single thing. Like, this person was here, this is what they saw. This person was here, this is what they did. So again, details. He afforded O'Keefe his Miranda rights, of which he is refused to speak. O'Keefe was afforded a phone call and contacted family. I'm sure he called John. And in that sense, I could see Karen bailing him out. Sergeant Pacheco placed O'Keefe into cell 3, where he awaited the arrival of bail. Clerk Magistrate Fregault was notified and set bail at $540 while waiting for bail. I contacted that doesn't seem like a big bail for somebody who like devastatingly paralyzed it sounds like, or could have paralyzed this man. I contacted the Lakeville Fire Department and spoke with the paramedic Pam Garrett in regards to the victim's status, medical Garant advised me that he was transported to Good Samaritan Trauma Center with internal chest trauma, head trauma, neck trauma, and trauma to his collarbone. So again, yes, I get it. People are gonna scream in the comments being like, well, John O'Keefe was sideswiped though, so he wouldn't have the same injuries. But still, nonetheless, you're being struck by a vehicle, and nonetheless, you're not even in a car. So you would imagine you'd have injuries, some kind of bruising, some kind of breaking, some kind of trauma outside just head trauma. I mean, this guy was hit head on. So dispatcher attorney Anthony Keeney advised me that a 911 call was from O'Keefe's vehicle, which reported his speed at 24 miles per hour. Wow, such a shocking coincidence. O'Keefe was later bailed by Clerk Magistrate Frigalt. So again, we don't know who. He was issued uniform citation, blah, 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 in his property and charged with the following. So this is what he was charged with: OUI, liquor, and serious bodily injury and negligent, operating to endanger, failed to yield the right of way. So that's Paul O'Keefe, guys. After hearing that, what do you think? I mean, he's not on trial, and I'm not going to shame him. Everybody makes mistakes, but you would think a guy who had similar experiences might be a little bit more empathetic towards Karen. I mean, it seemed like he didn't buy into the theory of her doing it initially. And we'll go through his testimony maybe in tomorrow's video. But yeah, interesting stuff. So this is a quick picture because I got to hop off in a few. But this is a picture from the incident. I mean, crazy damage. Crazy damage. And I believe that one is the victim's car. Crashing through Florida. Yeah, vehicle one. So this is the victim's car. So I don't know. Let me know what you guys think about all that. Again, we're not putting Paul O'Keefe on trial here, but it's just a little interesting. Coincidences. And speaking of coincidences, this was from The Sun. Again, I don't know if this is true or, I mean, it was reported on the 26th, like days ago. But a local resident has allegedly filed a lawsuit against the Canton police chief seeking more than $200 for a pedestrian accident last February, in which he was struck by the chief's SUV in a crosswalk. So another pedestrian incident. And can I do the rest of this? Let me stop sharing for a second. I had the full article up earlier. 1 second, guys. Hey, y'all, I found a better one because the sun is making me sign up a new crazy thing. So this is from Boston 10. Where we were streaming from before. Police chief in Canton, Massachusetts is addressing a case that she's been involved in. It's not Karen Reed, a controversial murder case that has divided the town. The chief actually hit somebody with her vehicle while driving in Rentham back in February. But she's only now making a public statement about it. So again, what is going on with Canton? All these police officers getting into to different accidents. I know that was my cat too. She was like, Canton Police Chief Helena Rafferty, which I believe she just got reelected for her position, so, or whatever, was cited at the time for failure to yield to a pedestrian in a crosswalk. Let me pull this up all the way. Exit that. When the police released video photos of Rafferty's town-owned Ford Explorer, what is with Fords, man, that was involved in a pedestrian crash back on February 16th. Rafferty said she was driving home at about 6:30 at night, attempting to make a left-hand turn similar to Paul O'Keefe. except he didn't hit a pedestrian. He was drinking and driving. From South Street onto Creek Street in Rentham when her lights caught a man in a reflective vest in the crosswalk. She said she hit the brakes immediately, but still struck 67-year-old Michael Berry of Rentham, who was walking with a cane. Yikes, the worst kind of person to hit. Berry was knocked to the ground and suffered a cut to the head. Witness said Rafferty immediately got out of her SUV, assisted Barry until first responders arrived and transported him to the hospital. So, I mean, I guess depending on who the witness is, she did it. She got out, tried to help him, and unlike Brian Albert, who didn't leave his home as a first responder. Rafferty requested a breathalyzer test, which the police report and photos show registered a .00. Yeah, because she didn't want to be caught. Like, I wasn't drinking and driving. She said she paid the civil citation for failure to yield, and the only damage to the SUV was a scuff mark. Police chief did not publicly comment on the accident until Monday, more than 6 weeks after it happened and after it had been brought to light by others. Yeah, because now everybody's looking at your department. What is a kitty cat? My cat loves this chair that I have now. Her statement said in part, I immediately notified Canton officials as to what happened. This was an unfortunate accident. Upon further reflection, considering the amount of attention that has been focused on Canton, I should have issued a statement sooner. Yeah, girl, you should have, because it looks really bad. So let's check out the clip.
The Karen Reed case, which has divided the town. The chief hit someone while driving in Rentham. This happened back in February, but she's only just making a public statement about it.
NBC 10's Alicia Palumbo live for us in Canton this morning. Alicia, what can you tell us about this?
Well, good morning, Latoya and Raul. What I can tell you is that the police chief here in Canton was actually cited at the time for failure to yield to a pedestrian in a crosswalk. Now, Rentham police released photos of Canton Police Chief Helena Rafferty's town-owned Ford Explorer that was involved in the pedestrian crash back on February 16th. Chief Rafferty says she was driving home at about 6:30 at night, attempting to make a left-hand turn from South Street onto Creek Street in Rentham when her lights caught a man in a reflective vest in the crosswalk. She says she hits the brakes immediately, but still struck 67-year-old Michael Berry of Rentham, who was walking with a cane. Berry was knocked to the ground and suffered a cut to the head. A witness said Rafferty immediately got out of her SUV and assisted Berry until first responders arrived and transported him to the hospital. Rafferty requested a breathalyzer test, which the police report and photos show registered a 0.0% blood alcohol content. She says she paid the civil citation for failure to yield, but says the only damage to the SUV was a scuff mark. Chief Rafferty did not publicly comment on the accident until yesterday, more than 6 weeks after it happened and after it had been brought to light by others. Now, Chief Rafferty's statement said in part, I immediately notified Canton officials as to what happened. This was an unfortunate accident. Upon further reflection and considering the amount of attention that is focused on Canton, I should have issued a statement sooner. Now, the chief also stressed her continued concern for the man that she struck in this pedestrian accident, but did not provide us an updated condition on him. We're live at Canton Police Headquarters.
Really concerned because I forget. I thought I read somewhere too that she was only I think that citation was only like $200. Like it was laughably low. And I'll try and pull those numbers later. I got to run because I do have a call with a client. But yeah, what is going on with Canton and their police department? And it's so funny how they're quick to document everything, take photos of everything. Chief Rafferty doing her blood and alcohol breathalyzer and all that, and they're documenting everything because it involves the chief, right? But when it comes to John O'Keefe, we have nothing. So that being said, what did you guys think about this trial? What do you think the next steps are? What do you think the Commonwealth? I mean, we heard it from a couple of different sources. Ted Daniel tweeted it. I don't know. It seems like the Commonwealth is going to move forward and try Karen Reed again, but is the federal investigation going to get in the way of that? Is the federal investigation going to help bring more light and into this trial? Are they going to bring forth more evidence that's going to be useful for the defense? And do you think they're going to be able to try it? I mean, they're certainly not going to try it in Dedham. They can't try it again in Dedham. So I wonder where else they would try it. Maybe Dighton, I just don't know. I have no idea where they would try this next trial. But that being said, thank you guys so much for watching. If you enjoyed today's video, if you enjoyed, again, my thoughts, opinions, feedback, you thought it was interesting, you want me to cover more stuff like this, we're going to keep a close eye on what is going on, what unravels over the next couple of days. So stay tuned. Again, we're going to be dropping videos every single day of the week. Probably dig into some of the Sandra Birchmore case as well, since that involves, guess what, Canton, and many of the key players we saw in this trial as well too. But if you like today's video, hit the subscribe button, hit the like button, and leave a comment too. You know, even if you don't agree with everything I said, I'm happy to have respectful conversations in the comment section with you below. So thanks for watching, and I'll see you guys in the next one. Bye.